national champion, undefeated University of Michigan Wolverines. I don't know if I've ever mentioned that before. Go Blue.
A single team bargaining unit is something that would be difficult to imagine, and it would not stabilize labor relations around the country.
The most popular question I'm asked at cocktail parties is, why does the NCAA have a one-and-done rule in basketball and a 3-year rule? People don't understand those are not NCAA rules.
Testimony by USC players and former players talk about 40 to 60 hours a week.
You're going to get rid of sports, aren't you?
Yes.
You're going to get rid of a lot.
This is a strange world. I don't know how we got to this point.
The ability to be able to reap those benefits equally, or at least significantly, by an athlete is necessary. Otherwise, we have slavery.
You get fired for not playing well?
Yeah, I wouldn't want to have been one of Rick Pitino's basketball players about a month or so ago when he went off on his rant.
They hire a Gestapo of students to follow them around to make sure that they're going to class.
There are some athletes that are getting 6- and 7-figure deals.
The joint hearing on the Subcommittee on Health, Employment, Labor, and Pensions and the Subcommittee on Higher Education and Workforce Development will come to order.
So I think in response to your question, one fundamental issue is, would academic matters be subject to bargaining? And so some of the academic support offered and eligibility rules, those sort of things. What is the play between collective bargaining and mandatory subjects of bargaining versus academic matters like study hall and extra tutoring and all those sort of things. But frankly, I think the answer to the question of what would change has a lot to do with the current engagement of both the institution and the student athlete. At Dartmouth, it is academic first in every sense of the word. And I think we would try and remain for it to be that way at Dartmouth and at St. Joe's, but being employees fundamentally changes the nature of that relationship.
You could just sort of tease out a little bit more about the fact that the world didn't come to an end, when NLRB recognized a right to organize, and that, universities benefited to them probably more than it cost universities, and that sort of seems very analogous to the situation we're discussing today.
You're absolutely right. Thank you for that question. The Columbia decision demonstrated most emphatically that the quest for a degree as a student is distinguished from the obligations and the benefits to the school that are gained through the employment of these students as employees. So employees have to do work. In this situation, the work of the college athletes will be playing the sport. The questions related to whether or not the academics will be imposed upon is not exactly on point, given the fact that the athlete's job will be playing the sport, and the athlete's activity relative to his or her degree is being a student. What we learned in Columbia was that the functioning of students as employees worked very well, and what was instructive in that regard was the public sector, where students had been employees for decades before the Columbia decision had started, and they have functioned very well. In fact, their abilities have been enhanced as a result of the security that they've gained.
Great.
This is an important subject. Just last week, I read the comments of great coach Nick Saban shortly after his loss to the national champion, undefeated University of Michigan Wolverines. I don't know if I've ever mentioned that before. Go Blue. But it was interesting as he talked about the reason he had decided to retire. And it wasn't because he lost to Michigan. It was because some of his athletes were coming in immediately after that, looking at next season and asking him what was in it for them. Basically, what contracts they would have. If the Dartmouth decision is upheld, what do you believe will happen to other private colleges in Division I, II, III with their intercollegiate sports?
Thank you for the question. I appreciate it. I do believe that if student athletes are classified as employees and the Dartmouth decision is upheld, I think it could really change the competitive balance in college sports. You're dealing with about a third of universities that are private in the NCAA. So you have about 2/3 that are public universities, and there are many states around the country that don't allow public employees to collectively bargain. There's also states like yours in Michigan who have specifically carved out student athletes as not employees, public employees. So I think about the competitive imbalance that could result from it. When you look at all the sports leagues, for example, those are league-wide bargaining units. The NLRB's history in issuing decisions around sports leagues have been about league-wide bargaining units. And it was something that was even mentioned in the Northwestern decision that a single-team bargaining unit is something that would be difficult to imagine, and it would not stabilize labor relations around the country.
So, Mr. Pearce, the NCAA and its respective divisions have shown that they are not capable of addressing every issue of concern regarding college athletes in a timely manner. They're also unable to produce an individualized solution in every case. So what are the advantages of an athletes union over the NCAA and division committees trying to resolve particular issues?
Thank you so much for that question. The ability for students to unionize gives the students a seat at the table in real time. So a union who knows the concerns of the particular athletes and the priorities that the athletes have with respect to equities and injustices can bring that forward in a collaborative way with the university so that the best solutions can be hashed out mutually, rather than some kind of top-down approach to say, well, we're going to try this, we're going to try that, and it may not necessarily work. The importance is that the students need a sense of better work-life balance. They know how it's imbalanced, and they can address it most effectively.
As far as trying to unionize, I don't think if you unionize, you got one choice, and everybody makes the same amount of money. So I don't know how you do that, because you take the NIL. Your quarterbacks are making $1 million, and I don't know if the linemen are not making that kind of money. So, and I worked in a union company, and if you had this level of skill, everybody made the same amount of money. And talking about name, image, and likeness, this is what has captivated this whole conversation. And now the Biden's National Labor Relations Board has gotten on board and says, hey, this is an opportunity to expand its authority and for student athletes and to employee status and unionization, which really will only serve to restrict student freedom and their ability to choose exactly what's the right course for them. And so nullifying these rules would empower athletes to make their own decisions about their...
Mike. No.
The most popular question I'm asked at cocktail parties is, why does the NCAA have a one-and-done rule in basketball and a 3-year rule? People don't understand those are not NCAA rules. They're collectively bargained. It's great for the owners because they get to see how athletes perform at the college level before they invest money and draft them. Those collective bargaining agreements, particularly in the NFL, basketball's getting better with G League and other options, they have collectively bargained football high school student athletes into one choice only, and that is to attend college, whether they have any interest in getting an education or not. And the fact that the college athletics is a free minor league for the National Football League, I mean, kudos to the NFL for pulling it off, but it's put college athletics in a very, very difficult position.
It could even be said that the educational scholarships which allow those other athletes to get an education are actually being, it's being won off the backs on the hard work and the daily training that the athletes from the high revenue sports provide.
That's correct.
And this whole idea that a seat at the table in real time, the NCAA has rules about how many hours an athlete can work during the term time and off-term time. Are those rules often not adhered to and violated, do you think?
They're substantially not adhered to and significantly violated. Testimony by USC players and former players talk about 40 to 60 hours a week of
So sorry, I only have 30 minutes left, 30 seconds, but the high stakes nature, the high paid salaries would give incentives to kind of not observe those rules and to not, the NCAA rules. Would not collective bargaining give the players the wherewithal and the leverage to have those NCAA rules enforced?
That's correct.
And I would further submit that rather than speculate whether collective bargaining would violate NCAA standards, I would say that collective bargaining has a chance, an opportunity to make sure that those standards are actually adhered to and enforced. The exact opposite.
Oh, that's correct.
I yield back, Mr. Chairman.
Percentage-wise, and if you can't take a stab at this, someone else can, what percent of athletes around the country are playing in income-producing sports?
Well, we start with there's roughly, I think it's 525,000 NCAA athletes across all three divisions. The only sports that typically generate revenues would be some Division I FBS teams. That would be the ones, the autonomy conferences, Big Ten, SEC.
Right, probably not Central Michigan. Right?
No, that's certainly true. Then you have Division I men's basketball teams. You don't, of that number, I think it's probably less than 20,000. If you add up the number of Division I basketball, men's and women's
certainly
athletes,
well under 5%, right?
Yes.
Yeah. What's the way you deal with increased cost? What are universities obviously going to do?
Well, then you're going to look to reduce costs, and I think what's likely to happen is the sports. We don't want to see a model, for example, be just the sports that
you're going to get rid of sports, aren't you?
Yes.
You're going to get rid of a lot, and that's even at Marquette where you got the big basketball team. At Wisconsin, at Oshkosh, at Concordia, to name two other universities in my district, who are losing money off the top. Can you guess wildly? I suppose it's unfair to do this to you. Guess wildly what sports would disappear, what athletes are going to lose the chance to play in sports because either they are classified as employees or even worse, become unionized?
Well, I'd say largely Olympic sport athletes. Some women's sports, of course, Title IX requires that there be, gender equity in terms of number of sports participation opportunities, equal treatment benefit. But I think a number of sports that are now intercollegiate will be downgraded to club sports.
Could you talk to us a little bit about what has changed since the Northwestern case was decided in 2015?
Thank you so much for that question. I've been waiting for this opportunity. Yes, I was chair when Northwestern was decided. The phrase the board got it right with Northwestern is not exactly accurate because the board never addressed the question of whether or not these football players in Northwestern were in fact employees. What they did was decide the case based on jurisdiction. The uniqueness of that circumstance was that Northwestern, a Big Ten school, was the only private school within a sea of public sector schools in that division. So it's about having a atmosphere where you can have reasonable, cooperative, and sensible collective bargaining to exist. To insert collective bargaining in that atmosphere where the board, and this was prior to the joint employer decisions, and even prior to the Columbia decision where students were recognized as employees, was not ready to be able to insert themselves into a situation where it may be chaotic given the dynamics of a private sector school within the sea of public sector schools. Things have changed substantially since that time. Those decisions that I just mentioned have been decided. The Supreme Court has spoken relative to the amount of control that the NCAA has over the universities as well as the students. So a question of a joint employer relationship is very real. And with the Supreme Court saying that the impositions that are being made by the NCAA creates antitrust violations, it has caused a clearer view of the relationship that student athletes have to their universities vis-a-vis the employer-employee.
This is a strange world. I don't know how we got to this point where we're considering unionizing college athletes. There's obviously a lot of it creates a lot of problems. Mrs. Bodensteiner, is that right? It is likely that the terms of a collective bargaining agreement between a school and a union representing student athletes would be inconsistent with the NCAA rules. For example, players could bargain for higher stipends or fewer classes to remain eligible to participate in collegiate sports. The university would be put in a bind of whether to bargain over subjects that could result in exclusion from the NCAA competition. What do you think that the schools should do in such a situation?
I think for some subjects of bargaining, absolutely. They could be in conflict. Let's say the topic is Sundays off, and your conference has, in the NCAA tournament, has Sunday games. So I think there could be situations where there may have to be a collective decision made between the employees and the employer to say, we can do that, but we wouldn't be able to participate, and let's come to some compromise. I think there would be many conflicts, not all. Some things would be, maybe more gloves, as my softball pitcher who I brought with me today. Provision of equipment and those sort of things would not, but certainly many topics would be also the subject of conference and NCAA rules.
I also understand that most of the programs and most universities don't generate profits for their athletic programs, which is in keeping with what it was intended to be from the beginning. That it's about academic performance, academic achievement, athletic achievement, not necessarily selling ads and selling tickets. So can you discuss how how this might financially impact universities?
Yeah, none of our 21 sports generates a profit. A few generate revenue. We don't sell tickets to anything other than 2 sports. And so, as I mentioned earlier, I think just the costs of having a student-athlete workforce, we currently have 480 student-athletes at St. Joe's, and just the infrastructure of, the human resources, the bargaining personnel to manage potentially 21 bargaining units and 480 employees would be extensive. Costs that I think decision number one would be, okay, if there are wages now involved, again, at institutions like mine, what does that do to the financial aid? I think that's where the money would have to come from. And
Right.
So I worry that the access to collegiate or to college would be decreased at some institutions.
So what would be the rationale or significance in banning these athletes from collective bargaining or even organizing if they technically meet the standard of what is considered an employee?
Well, the only advantage I can see is that it keeps the money in the pockets of those who are gaining the substantial revenues. As you stated, the NCAA is a multi-billion-dollar organization. These schools profit significantly through their partnership with the NCAA. The whole question of athletes being able to unionize provides an opportunity for the athletes to get some of that revenue that they have earned through their labor. We're talking about sports being a job here, and it's a job because of the benefit that it provides these institutions as well as the NCAA, and the ability to be able to reap those benefits equally or at least significantly by an athlete is necessary. Otherwise, we have slavery.
Professor Mitten, employees can lose their job. Employees, if student athletes are employees, let alone whether they're a professional play on the field, but they could get fired for just not living up to expectations. Is that true? I mean, we could fire a student employee, they could get fired for not playing well?
Yeah, I wouldn't want to have been one of Rick Pitino's basketball players about a month or so ago when he went off on his rant. Now, there could be some protections in the collective bargaining agreement which would provide for a grievance being filed, but that's a rather cumbersome procedure, of course.
You indicated there are factors the NLRB will consider when deciding whether or not a team can unionize. What factors would they consider?
Well, thank you for that question, and how you doing, Mr. Scott? It's good to see you again. The important factors to consider is the degree of control that the university has over the students with respect to their responsibilities and their obligations in training and performing the sport, and how it affects their life, their student life throughout. There's been testimony where students have to work 40 to 60 hours. They have to comply with particular regulations. They have to get approval to even get haircuts. Some students have been required to get scanned, and they hire a Gestapo of students to follow them around to make sure that they're going to class. Those kind of elements of control are key elements in determining whether or not the relationship is an employer relationship.
I understand that if you get an athletic scholarship, you can't be cut from the team.
So the NCAA recently passed rules that are in place now, not just at the Power 5 conference level, the FBS Autonomy Conference, but across all Division I schools, that if you receive a 4-year scholarship going into school, that scholarship can't be revoked for athletic purposes. Before that, it was a 1-year renewable scholarship.
Can you be cut from the team?
I didn't have anybody that was cut from a team when I played. I don't know anybody that was for athletic performance reasons. There were people that left because they weren't getting the playing time they hoped for, so maybe they left or transferred, but I didn't have anybody that was cut from the team.
Okay.
Ms. Bodensteiner, do you believe that legislative efforts could help to make sure that college students are receiving meals while they are on the university campus?
I think all students need to and deserve to have meals when they're on campus. I've been, horrified at the concept of reducing or doing away with Pell Grants. That's been spoken about, and athletes can receive Pell Grants, and many do, although at our institution it's less than 10% who are Pell Grant eligible. But I'm in favor of any legislation that helps give college students in general access to food.
Professor Mitten, collegiate sports have undergone transformational change in recent years. Student athletes may monetize their name, image, and likeness and more freely transfer schools without losing eligibility. Given these significant changes, do requirements still exist to maintain the educational primacy of intercollegiate sports?
Yes, very much so. Chairwoman Fox. If you look at the 2022 NCAA Constitution, student athletes are much better off than they were in 2015. In fact, I would say there's no better time in the history of the NCAA, going all the way back to 1906. Student athletes have it very well. I mean, there's scholarship protections at the Division I level. They can get multi-year scholarships, full cost of attendance scholarships, and individual schools, if they want, can provide academic bonuses. Above that, just simply for meeting grades, you can get up to almost $6,000 if a school chooses to do it. And then certainly NIL rights. There are some athletes that are getting 6- and 7-figure deals.
Am I correct that the Dartmouth case only affects their men's basketball team, not their women's team or their volleyball teams or other teams at Dartmouth?
That's correct.
Thank you. And it doesn't automatically affect other schools. Am I right about that?
No.
Or will it only affect other schools if athletes pursue employment recognition through the law and insist that they're similarly situated?
That's right.
First question for you is, if the NLRB's decision in the Dartmouth case is upheld and student athletes are classified as employees, what would the financial impact be on college athletic programs?
Thank you for your question and for your service to our state. The college athletics is currently not set up to manage a student athlete workforce. We have 480 student athletes, the administrative and infrastructure that would be required, and as Chairman Gaston Pearce noted, there could be 21 different bargaining units among my 21 sports, and that would be an incredible expense to the institution to try and manage that. Not to mention if there were negotiated benefits as part of that. So I think the cost to institutions would be great. And thank you also for acknowledging at St. Joseph's University, where we do not make a net profit by any means, our coaches are teachers. We are here because 95% of women who have reached the C-suite and Fortune 500 were athletes. That's why we're doing what we do. And to change this from the teaching, the mentoring, and the developing into a student-athlete workforce would be incredibly, go against everything, every reason we support it, but more importantly, would cost a lot of money.
You and I are making the same point. Today's student athletes have a lot of flexibility. And if they become unionized or collective bargaining under this situation, we're taking away, as it seems to me, you can disagree, we're taking away a lot of flexibility from student athletes.
Yeah, and it's not only the flexibility, it's the student athletes coming into the school and being potentially subject to that collective bargaining agreement that they never agreed to, right? Or choosing not to go to that school because they have a collective bargaining agreement and that school potentially suffering.
Seems like we're opening Pandora's box.
But wasn't that part of the Alston decision, which was a unanimous decision? The opinion was written by a Trump appointee, Justice Gorsuch. I've already used the quote from Kavanaugh. Wasn't that acknowledging what we've been living under? I mean, from a legal standpoint, the Supreme Court said these are not amateurs.
That's right. And the Supreme Court further said that collective bargaining is warranted because of the imposition on the lives and livelihoods of these athletes that the NCAA creates.
Would you venture to estimate what the cost of employment status might be for the typical D1 university? What would that cost be, maybe on a monthly, weekly, annual basis?
I haven't thought through it from that perspective, but I can say that adding 480 student-athlete employees would be about the same number of employees we have currently. So you can assume you'd double your human resources department. And I think the infrastructure would be considerable.
Well, I will just give some estimated raw numbers. Let's just say you've got typically 500 student-athletes at a D1 school. Let's say you're going to pay them $20 an hour. I don't know if they would negotiate if Mr. Pearce and others had their way for $20 an hour, but let's say it was $20 an hour for 20 hours a week, and they do not work more than 20 hours a week. That's a misrepresentation also, by the way. So let's say you had to pay them $400 a week times 500 student athletes. That's $200,000 a week. If you annualize that, and I realize they're not the full 20 hours a week during the so-called off-season, there's no off-season, but that's some $10 million a year for the typical D1 institution. And without objection, there being no further business, the committee stands adjourned.